I know it's an early start, a very non-New York start time for us, but to fit everything in, we're getting a little bit early of a start this morning. So thank you all very much for coming, and I hope you're as excited as I am about the day we have ahead planned for you. Before we do anything else, though, I hope you will please join me in thanking Courtney Oliva, our center's executive director, because she did everything. She did absolutely everything that you are about to see today, getting all these all-star panelists together, the keynote conversation that we're going to see between Emily Bazelon and Dwayne Betts, all thanks to Courtney, with a tremendous amount of research in advance. So I think you will see the fruits of that and how organized and thoughtful everything is. So thank you, Courtney, for everything. And it's really even more amazing when I'm about to tell you all the other things she's been working on this year, because Courtney is basically our center, along with student fellows. We're a small shop, but we try to do a lot with what we have. So I did want to just give you a quick update on what we've been up to since our last annual conference, just so you can keep up with the things that we've been prioritizing. So you may recall that we've been doing some work on reentry issues, and we published a report on the prosecutor's role in reentry. And we were very happy since that publication in late 2017 that it's received a citation by a judge who found it helpful in an opinion. It's gotten some press in the appeal, and we've been using it to help elected prosecutors with trainings. So our hope is that prosecutors will pay more attention to these reentry issues, and we will get better public safety outcomes as a result. We've also been very active and remain active on the clemency front. We are still trying on the federal front. I was happy to see at the end of last week, Senator Amy Klobuchar, who you may know is running for president, released an op-ed outlining her agenda for criminal justice reform, and one of her top priorities is a clemency plan that Mark Osler and I have been touting for a while now, which would take clemency decisions outside the Department of Justice, the agency that brings the cases in the first place. We thought it might be a good idea to have somebody else take a look at the clemency petitions, and we were happy to see that somebody thought that was a good idea as well, who might be in a position to do something about it. And we keep working with anyone else who's interested on these issues, any other candidate and the current administration. We are trying. We are also shifting our focus to the states and state clemency efforts. So we now have a state clemency reform project that's led by our center research fellow, Ben Noterman, and he has done 2 amazing papers already outlining the history of these practices in Massachusetts and Pennsylvania. And our goal is to try to show people that the sharp declines that we see now in clemency and taking a second look at people's sentences, that's really new. It's relatively new. We used to have robust looks at people and how they changed over time, and their sentences were reduced as a result of that, oftentimes dramatically, and even when their crimes involve violence. So the idea that you couldn't see that people would change and circumstances would change over time is a new one in our history, and we are hoping to show people that, so the idea of bringing it back won't seem so foreign. Also, Courtney has been working with our student fellows to try to get clemency for individuals here in New York. Stay tuned. And then finally, last thing I just wanted to highlight for you, as you know, we often file briefs in cases that involve issues that we care about on the criminal justice reform front, and in particular, issues that involve prosecution practices that are troubling or that we think could be better. So working with lawyers at WilmerHale, we filed a brief in a pending case before the New York Court of Appeals, trying to urge better practices on disclosure for prosecutors in cases involving jailhouse informants. We've also partnered with Boies Schiller and along with the ACLU and other organizations to file a brief in the Eastern District of Louisiana to argue that prosecutors shouldn't get qualified immunity when they send fake subpoenas to crime victims and witnesses in order to try to get them to speak to their office. And most recently, with Covington and Burling, we filed a brief at the Supreme Court urging a more favorable statute of limitations period for defendants to bring 1983 claims in cases where evidence had been fabricated against them. So today's event continues our concern with prosecutorial practices, and the one we're concerned with today is a big one. one, which is plea bargaining. And what we hope to do today is learn from the very best people who've been thinking about this issue, and hopefully do the same thing as we've done with past conferences, take what we learned today, put those ideas into briefs and policy papers and trainings, and hopefully make things better based on all the great thoughts that our panelists are going to give us. So we'll start with panel one, and I guess the folks from panel one should come on up and get themselves ready. And thank you all so much for being here today.
Great, well, let's get started. And before we do, I just want to give very brief introductions of our esteemed panelists so they can get the conversation underway. To my immediate left, we have the Honorable Stefanos Asbibas, who is a United States Circuit Judge on the Third Circuit Court of Appeals and was previously a professor at the University of Pennsylvania Law School, where he has written extensively about prosecutors and plea bargaining. To his left is Vanessa Potkin, who is the Director of Post-Conviction Litigation at the Innocence Project, where she has been since 2000 as one of its first staff attorneys. To her left is Suja Thomas, the Pierre and Sarah Pedersen Professor of Law at the University of Illinois College of Law. She's most recently written a book called The Missing American Jury, which questions the constitutionality of plea bargaining. So I think we'll have some really interesting things to hear from her today on that front. Further down, we have Scott Heschinger, who's the Senior Staff Attorney and Director of Policy at Brooklyn Defender Services, which is one of the largest public defense firms in the country, and he's also an NYU law grad, so we're very happy to have him back.
Good to be back.
And then last but not least, we have Dan Satterberg, who is the King County Prosecuting Attorney. He was elected to the position in 2007 and has been in the office for over 30 years. So with that, Judge.
Thank you, Courtney. Thank you to NYU for having all of us here. And so our panel is titled Plea Bargaining, a Necessary Evil. So we're going to try to leave some time at the end for audience questions, so please save up your best questions for the last 15 or 20 minutes when we'll call on you. First question for the panel. What's the real problem with plea bargaining here? Let me start with Scott Heckinger. From the point of view of the defense, there are a bunch of different explanations out there, but what couple of them do you think are the ones that trouble you or defendants the most?
Okay, so the panel's called A Necessary Evil. There's also a question mark at the end. So first of all, I would just say I think plea bargaining in isolation, just forgetting everything else, is necessary to the extent that it's one of the few tools that we have as defense attorneys and our clients have as defendants and the accused to actually sometimes get leniency, the fair outcomes. There's very little else that's out there right now that's embedded in the system that allows us to actually have occasionally, all too infrequently, but sometimes good outcomes. It's not necessarily, plea bargaining, it's not necessarily evil to the extent that, again, in isolation, assuming that the parties are an even playing field when it comes to power, to risk, even power when it, or even playing field when it comes to incentives. We want litigants to be able to communicate with each other, to work with each other, to hopefully come out with what's the best outcomes for public safety, from a cost perspective, from a fairness perspective. The evil, I think, is in the context within which these conversations and bargaining are actually happening, the context of pretrial justice as we see it today. A context of mandatory minimums, pretrial detention, and imbalance of information. And so my clients, are often making decisions or forced to make decisions in the most powerless position you could possibly imagine. Behind bars, their life crumbling on the inside, facing intense violence, their lives on the outside crumbling, bills piling up, people in need of caretaking left without caretakers, and willing to do anything, up to plead guilty to very serious crimes, even if they're innocent, or to suck it up and put up with bad police practices even though their rights were violated, just to go home. Pair that with mandatory minimums, which have a built-in automatic risk component, but only to the defendant. So you can go to trial, you can exercise that right, you have that power. But if you do, you might win, but you also might lose, and the judge could be your best friend, your mom, your brother, and you're going to get that 3.5 years. So the prosecution in that context knows that they could offer anything less than that 3.5 years, that 5 years, and it's a good deal. Few people go to trial because generally trial is an unreasonable decision to make. And then you've got an imbalance of power. So most discovery laws around the country allow or put prosecutors in control of most of the information. And tied into plea deals, there was a recent decision by the Supreme Court that said that it is okay, it is constitutional to withhold or to not turn over Brady, exculpatory material, before a plea bargain or before a plea. And so you have this combination of forces where we want to be able to have a good conversation, an informed conversation, a conversation that will ultimately produce good outcomes, save taxpayers money, end the case early, not have to put survivors through the trouble of trial, but produces evil, I would call them, outcomes that are not just, outcomes that are costly, outcomes that do not enhance public safety because of an informational deficit, because of a risk imbalance, and because of a power imbalance. And so I think we have to look to the laws and the context within which these conversations are happening, and also realize that often, all too often, we're not dealing with good faith actors. From the prosecution standpoint, I think all too often the incentive structures in prosecutors' offices are built around an incentive of winning at all costs as opposed to doing justice. And we're seeing that change around the country. I'm excited to be sitting next to D.A. Satterberg and hear more about his efforts to do just that. But I think we have to contend with prosecutors' offices and incentives there, but also the laws that drive pretrial justice.
Interesting. So I heard you focus on coercion, on some lack of information and some safeguards, maybe some inaccuracy. You're implying that you think the plea discounts they're a good thing, but at the same time they're so big that they're coercive for a lot of defendants. I didn't hear you say much about inequality. Do you notice disparities?
Well, I notice disparities to the extent that the majority of my clients, all of my clients cannot afford to pay for an attorney. So all of my clients are indigent. The vast majority of my clients are Black and Latino, and they're from only certain neighborhoods. So built into the structure of the system of plea deals is the fact that only certain people are coming through the system to begin with. And so if we're ever to make the system more equal, the plea bargaining, we have to be thinking really critically about who's coming into the system, who's getting arrested, who's getting charged, what are they getting charged with, who is ending up incarcerated pre-trial. And unfortunately, the way that our system operates today, the majority, it's predominantly Black and Latino from only certain neighborhoods. And so there's a built-in inequality, racial and also socioeconomic.
Okay. Vanessa, from the Innocence Project perspective, how does this play out in terms of factual inaccuracy, moral, legal inaccuracy on guilt, on sentencing?
Mm-hmm, exactly. So, when you look at the total number of non-DNA or DNA and non-DNA exonerations that have occurred, there are about, 21 people whose convictions have been overturned based on innocence. And 18% of those people pled guilty to, for the most part, very serious crimes, rapes, murders, robberies, that they didn't commit. When you look at the DNA exonerations, that number is about 11% of the just over 350 people who have been proven innocent with DNA. And, some of the reasons that people have pled guilty in these cases where they're, pleading to very serious time and to serious charges that they're completely innocent of, have to do with the tremendous sentences that they're facing. So, if you look at the case of a man named Brian Banks in California, he was a high school student who had been falsely charged with a sexual assault of a classmate. And he had a very promising football career on the horizon, was being scouted by USC, and basically was facing up to 40 years for, if he went to trial and was convicted, and the offer that he received was 5 years. So, his public defender said, take the 5 years, you're gonna come out, you'll still be young, you'll have a life ahead of you. If you go to trial, it's one person's word against another, and if you lose, you're in for 40 years. So he took the 5 years, and through a miraculous twist of fate of the accuser acknowledging that she fabricated the case, he was ultimately exonerated. But, what is the rational choice in that circumstance? It would be completely irrational, in a sense, to go to trial. And then couple that with just, the other aspect, in addition to, everything that Scott just talked about, just the, crisis of indigent defense, and, in many places throughout the country where many of our clients, through the Innocence Project, met their lawyers on the eve of trial, they're not getting the lawyering that's coming out of Brooklyn Defenders, and just don't have access to investigators to look into the case. So if you're facing that much time and you're not meeting your lawyer, what are you to do? And so, we view the guilty plea problem, really the problem part of it, again, is, as Scott said, the context and these other areas in the system that are failing.
Thank you. So Dan Satterberg, the prosecutorial response, we've heard some process complaints about poor information, poor lawyering. We've heard two perspectives. On the one hand, the leniency is desirable for a lot of defendants, but the flip side of that looks like coercion to some, and even the fear of innocence. How big do these loom in practice, and what safeguards do you see on the ground from where you prosecute in Washington?
Sure, thank you, Your Honor. So, when Courtney first called me to talk about this issue, I hadn't thought about it very much. It reminded me of an old parable that attributed to David Foster Wallace, it's a short one. Two fish are swimming by, and they see an older fish who goes, "Hey boys, how's the water?" And the one fish turns to the other and goes, "What the hell is water?" They hadn't thought about it. It's part of the environment that they live in. And I think every system in America has a certain disincentive to go to trial, and that's a survival instinct for all of us. We can't take 100% of these cases to trial. My office files about 7,000 felony cases a year. We do 400 to 500 trials, and we are packed. Our people can't do more than that. And so there has to be some way to make those cases resolve themselves. And so, and a lot of it, what we talk about is really a matter of word choices, of the lexicon that we use. So in my office, we file, our filing standard would be a conservative filing standard. We're going to file the smallest number of counts that will accurately reflect the conduct. Now, many other counties, I call that conservative filing, many other counties, including the one just south of me in Tacoma, have files what I call the kitchen sink approach, which is they file everything they can think of. It's like a law school exam. Just throw all that stuff. And then for an early plea, they'll dismiss 90% of it. And so I have the attorneys who operate in that county come to me and say, well, why don't you do that? Because that'd make my job a lot easier if I went in and said, look, I got this great discount. They got 90% of your cases are going to be thrown out. And instead, we have the trial penalty. Now, nobody likes a penalty. Everyone likes a discount. But we arrive at the same place for that same reason. And I think the evil in that, or the problem in that, is then when it's too much gamesmanship, and when we lose sight of what I talk to my office about is the maximum justice value of any case. It's like buying a car, and I hate to denigrate used car salesmen and compare them to prosecutors, but that car has a value. And if you're a good negotiator, you can get it for a little bit less. If you're a bad negotiator, you can pay a little bit more, but you're not going to pay like 4 times more than the guy who couldn't do it well. Every set of criminal facts has, I think, an inherent value that and if you've been doing this long enough, you have the perspective and judgment based on experience to know how this case relates to another one. And the cases that we've been looking at now to go back, and Rachel talked about the second look thing, we're starting to go back and look at some of the cases that happened in the 90s in my office. We handed out really long sentences in the 90s for stuff that today we wouldn't do. And partly it was because of the adversarial system. sometimes the personalities of the attorneys who didn't like each other couldn't come to an agreement. And so I'll show you, you wouldn't take my reasonable offer, I'm going to add everything I can think of, and all of a sudden you're looking at a 40-year sentence for a non-homicide case, and we were all like taken aback looking at it in 2019. So the evil of it is, it is necessary, but it has to be tempered by a price tag that you cannot exceed. And later I'll offer some suggestions about how we might do that.
I think the price tag metaphor is very interesting and important. I mean, I think there's a lot to be said for being more transparent, but it's difficult to do. Number one, what's the baseline? You say trial penalty, plea discount. Some people think this is excessive leniency, like it's a bargain. But if everyone's getting it, is it? And if you have a culture, as you said, from Tacoma, where most people expect the discounts, it can be hard to move to a more standardized, less haggling. The defendants feel like, well, I didn't get anything. So even if we agree that's a better place to be, it can be hard to get there, maybe. I want to talk to Suja Thomas for a minute now about some kind of outside, like more academic and theoretical perspectives on this. So people inside the system kind of take this for granted. This is all about, well, does the defendant like it? Does the defendant benefit? But even if we could fix the lawyering problems and the information problems, what's the kind of constitutional or public justice problem with plea bargaining?
Yeah, so all of this has to do with the right to a jury trial. The United States jury was based on the English jury, and that jury was such that grand juries decided whether cases proceeded against criminal defendants, and juries decided whether defendants were guilty of crimes. And so you actually had 24 people standing in the way of someone being convicted. So right now, in the vast majority of cases, and I don't think we've even mentioned the stat yet, but it's about less than 3% of cases are tried by a jury. And so in almost every case, we have one person effectively standing in the way of someone going to prison. And I think that's problematic. And so our Constitution, our jury provisions of the Constitution were based on that English system. And that English system was nothing like the system that we have today. Virtually everyone insisted on taking the jury trial, and almost no one pled guilty. And if you pled guilty, you didn't receive a benefit to pleading guilty. You received the same sentence that someone would receive if you actually were convicted before a jury. And the United States Supreme Court just shortly hasn't recognized this. They've just sort of said, effectively, efficiency is important to our criminal justice system, and we need to, we won't have enough resources to actually try these cases. But what they actually also have said is that our jury in the United States is actually based on this English jury. Why? Because otherwise, what happens is exactly what's happened today, and that is there's a grab of authority. And that is, we make up a system that didn't exist back in the day. That is, you could not attach a penalty to the right to a jury trial. And so because we permit this penalty to be attached to the right to a jury trial, we have the system that we have today, and then we justify it in terms of efficiency.
But what's wrong with that? I mean, in our society, you know, efficiency and quantity, they're measurable. You maximize that, you get more deterrence, you get more incapacitation, and you have it being done by experts who know this case is gonna wind up there. What's wrong with saying, well, let's have the largest number of cases processed? The defendants, they get a lower sentence than they would otherwise. The prosecutors, they get to maximize incapacitation. So what do we lose with that trade-off?
So, first of all, I want to just sort of point out, because I think we lose sight of this, the Constitution doesn't say anything about efficiency, at least with respect to, people can argue about certain provisions of the Constitution, but you can't say that with respect to the jury provisions. Article 3, Section 2 says the trial of all crimes except in case of impeachment shall be by a jury. And then the Sixth Amendment refers to the right to an impartial jury. And so in the first instance, there's absolutely nothing in the Constitution that actually refers to efficiency. And then I just think we lose sight, I know some of what other people have said kind of goes to this, but we lose sight of the fact that the jury is actually supposed to be checking other parts of the government. We have now lost that. We don't have a check on prosecutors. We don't have a check on the laws. I want to mention really briefly, some of you have seen or have heard about the Lorena Bobbitt case because it's back in the news because there's a documentary. And so for some of you who are maybe too young, might not know about the case, there's some salacious facts. Lorena Bobbitt cut off her husband's penis, and she was prosecuted for malicious wounding, and she was offered 4 months, but for the plea deal, but she would actually be deported. And then she was told that she would get 20 years in prison if she took the jury trial. But this was an extreme situation. She did not want to be deported. The United States was this incredibly important place for her to be. And so she went to a jury trial. And at that jury trial, what came out was that she had been subject to lots of abuse by her husband. She had been raped. The police had been called numerous times. The jury, at least one of the jury members was interviewed in the documentary, and he said no one really believed that she was not guilty by reason of insanity, but they found her not guilty by reason of insanity because they didn't think the law adequately protected her and that she should not be convicted. And that's one of the rules of the jury, and that we don't have, and that is a check on the legislature, it's a check on the prosecution.
So let's unpack that. One thing you're saying is separation of powers, we need an additional check. But the bit about the law not fitting is a different way of approaching the issue from the way that the prosecutor is approaching it when charging, or the judge is approaching it with. So there's a kind of an equitable or populist perspective that's required to nullify this. Now, the response might be, well, plea bargaining happens in theory in the shadow of the trial. Can't the prosecutor and defense lawyer forecast the jury's going to be sympathetic to Lorena Bobbitt? Why isn't that bringing down the sentence? Now, I've written my own stuff kind of questioning how well the shadow trial works. I'm kind of curious from your perspectives, when you go, Scott Hechinger, when you are plea bargaining with a prosecutor, how much does it constrain the prosecutor's offers to say, hey, this is not going to play well at trial, this is a case where there's a real chance of acquittal, you need to come down here, you need to dismiss a charge or something like that?
You know, I can't tell you often because I don't know what evidence they have. Often don't know who their witnesses are. I don't know about the conversations that they've had with their police officers when they're police officer cases. But what I will tell you is often on the eve or the day of a hearing or a trial, suddenly, magically, the offer comes way down. And I'm in this position where I'm having this conversation with my client. I'm like, something's up. Mm-hmm. You know, they had a conversation with that police officer and something they said didn't match up. And we can, but they're offering you, instead of the 2 years on this gun possession, they're offering you a violent felony, a nonviolent felony, and probation. There's no chance you're going to go to jail, and we're in front of a judge who I can tell you, just based upon the charge, is very unlikely, no matter what that officer says on the stand, not to suppress the gun, and you're dead at trial. 3.5-year mandatory minimum. So what are you going to do at that point? And it's always it's so frustrating because there's that information deficit. You know, I would think at that point, if there's questions about credibility, the duty is not to offer less so that you can get your conviction and move on. It's to dismiss a case if you actually find that there's credibility issues, or at least ask for an adjournment to investigate further. But this ties to another piece. We're talking about, the loss of the jury trial. Another thing that's lost is the suppression hearing, right? The Fourth and Fifth Amendments are based upon the idea that government hands off the people. And the key way to keep government's hands off people is this exclusionary rule. And the exclusionary rule is based on the possibility of a public defender or a defense attorney challenging a police officer on the stand and holding them accountable. And if the judge finds that there isn't justification, the prosecution can't use that evidence. But the reality of plea deals is that accountability, that disincentive to do bad police work is lost. And what's even scarier is even in those very few cases where I actually am able to cross-examine a police officer on the stand, and that police officer is even found to be incredible. So we're talking about like a 0.02% possibility. That's actually the number of 0.3% of misdemeanors that were prosecuted in 2016 went to a hearing. So even less percent of those where there's a finding of incredibility, prosecutors' offices still continue to rely on those officers. And even the judges who find them incredible continue to rely on them for making out search warrant applications. So there's just, the plea deals and plea bargains and guilty pleas not only suppress the jury trial, but it also suppresses police accountability. And it's just a big part of why police violence and bad police practices continue.
But there's a tension to what you're saying. On the one hand, you said a lot of defendants like the pleas, they benefit from them, but other defendants are losing out from the positive externalities, the public goods of the accountability of the officers of bringing this to light. And you're in a position where you have to represent the many defendants who want to jump at the pleas and the others who don't. And some of them, they know the information. They know I did it. They know the witnesses are going to be there, and others of them don't. But collectively, some of them are being made worse off by the decisions of others not to challenge these practices. And you have to represent these very varied interests. You can't say to one, no, it's a bad thing. We should just all be taking these bad officers to trial or suppression.
No, and I don't think there's tension to the extent that that's the reality in which we are, the practice exists. But it's not inevitable. It's not inevitable that we have mandatory minimum sentences that create this bad incentive. It's not inevitable that we have discovery laws that empower prosecutors to withhold all evidence, even exculpatory evidence, until close to trial and not turn it over before someone can make an informed decision to plea. It's not inevitable that pretrial detention should exist. That creates just immeasurable power and incentive to plead guilty just to make something go away over all other interests. And so if you got rid of those, I think, three pretrial justice issues, or you fix them dramatically, you'd be able to have better outcomes as a whole. Not perfection, because it still relies on two players in the system operating in good faith, and also just thinking, like, what is a bargain, right? What is a good bargain? Is it just that car? Is it just less time? Is it incapacitation? Or is it necessary for defense attorneys and prosecutors to be really thinking about the system in the same way? So thinking about it as something where jail actually doesn't make us safer. Recognizing that it actually damages people more than not, that people come out far more damaged than when they went in, that it doesn't actually help survivors, that locking up people and arresting people for things that were formerly thought of as societal ills and public health issues shouldn't be in the system to begin with. And so I think that's another broader issue too. When we're having that discussion, what is the right outcome? I have ideas about it, and I've had some really, really incredible conversations with especially newer prosecutors coming through when we're talking about they'll offer 2 to 4 years for someone or they did offer for a client of mine 2 to 4 years for stealing 12 Red Bulls and a pack of cigarettes from an Aereo bodega. And my conversation with the prosecutor was, all right, I'm going to meet you where you are. Like, I step beyond just I don't think 2 to 4 years is healthy for my client, and I'm just backed out. Let's talk about public safety. 2 to 4 years, 2 years he's going to be eligible for parole. Even if he doesn't get on parole, he'll be out with good time after a little bit after three years. He's going to come out. The issues that were underlying that conduct, which were substance abuse and mental health, are just going to be worse. He's going to have the scarlet letter of a criminal conviction. He's going to be precluded from public housing. He's not going to be able to get a job. He's going to be further marginalized, and he's going to be more likely just to come right back in. And I had that conversation with the prosecutor, and he's like, I totally feel you. Let me go speak to my supervisor. And the supervisor, who's been in the job for 10, maybe 15 years, who's used to doing this as it always has been, more often than not says no. Now, I was able, actually, in that case, to work out an alternative to incarceration. And instead of him coming out 2 to 4 years, he came out 2 to 4 years worse off. He came out a year later, clean and sober for the first time. And so that's an example where you can hopefully sometimes have a meeting of the minds. There's still institutional kind of status quo and inertia, but that's the hope, and why I wouldn't say let's definitely not set minimum boundaries on how lenient we can get. We've seen how that's happened in terms of mandatory minimums, but we can do a lot better, obviously, in terms of coming to a meeting of the minds and taking away these inherently coercive pretrial laws.
Vanessa Potkin, could you pick up on a couple of these points? One of them is information deficits. Why is, in the cases you're seeing, can you generalize about the kinds of cases where people don't know and can be bluffed, or why is it that defendants not knowing, okay, either I was there or I've got this alibi, why isn't that enough? And what of these pressures to plead, the pretrial detention and the like, are doing the work of getting some of the clients whom you later exonerate to plead to something they didn't do? To most of us, it's unimaginable that I would ever plead to something I didn't do, but could we identify like a high-risk population that at least needs more scrutiny here?
Well, I think that, really a lot of it has to do with the disparity in sentencing, and what is the ultimate, what's the threat, what are people facing? In our exoneration cases, we've seen people in states that have the death penalty who are facing a potential, sentence of death. And so they end up taking a plea out of fear to even life, and so this sentence disparity, we are working on several cases right now that are current cases where our clients were offered 10 years and then went to trial and received life sentences. So I think the disparity in sentencing for taking a plea versus going to trial and the penalty, and the NACDL has done great work in this area to expose the trial penalty, is really one of the driving forces. Also, I guess in addition to the list of pretrial justice issues, I would, add what's been touched upon, which is just, the mindset of prosecutors of the ultimate goal being either to obtain or to defend a conviction. So in many of our cases, what we see where we have post-conviction developed evidence of innocence, even exclusionary DNA, so very scientific, proof, concrete proof of innocence, instead of vacating the charges in a case which clearly meets a newly discovered evidence standard, prosecutors will come back and try to offer some type of sentence modification, time-served plea, and talk about bargaining at that, what's fair at that point. Our clients have already served, oftentimes 20 years. They want to come home to their families. Their kids have grown up without them, and they're being offered, if you just, accept this sentence modification, the prison doors are open, and we know we can win ultimately with the exculpatory evidence, but through the court process, it could, we could win in the trial court, the state could appeal, we can't guarantee that it's not going to be, many more years of fighting. And so some of our clients have the stamina, and some just, want to get home before their mother dies, and so they end up, accepting the plea. And in those circumstances, it's just also unconscionable when you have proof of innocence, and that's the resolution that's really being extorted. So it's just also, I think, changing the mindset of not, it's not a loss to dismiss a case when the case shouldn't have been brought, or we know now that the person is innocent, or there's a good chance that they're innocent. We've had prosecutors, kind of resolve a case through an Alford plea to resolve the case ultimately and stand up in court and say, we know if the conviction is vacated, we wouldn't be able to obtain another conviction today, and so we're offering an Alford plea, and that just seems to be fundamentally unfair.
Suja Thomas, let's back up to the bigger picture here. My guess is you'd say that we're arguing about, details. I don't know if you'd say deck chairs on the Titanic, but you think there's a more fundamental problem, because the problems we've been hearing about, maybe you could just deal with the Alford pleas, maybe you could deal with the size of the sentence discount, but they wouldn't address your concerns, citizen participation and transparency and checking. Do you think all plea bargaining is unconstitutional? Do you think even implicit plea bargaining, just the judge gives a discount, there's no dickering, and the defendant gives up the unwinnable trial, moves on? Do you think there's a problem even with that?
So I do. I would say that with respect to cooperators, there's an historical precedent for cooperators getting a deal. But outside of the situation involving cooperators, I think there's no justification for plea bargaining. It again goes to sort of what Vanessa has said and others have said about the trial penalty. If you have a trial penalty associated with the plea bargain, I actually think of it as plea coercion. I think plea bargain is not an accurate way to think about this issue. Then you don't have a right. You don't have actually any kind of right to a jury trial. When you attach a penalty or a tax to the right, that there is no longer a right.
But there were, certainly at common law, there was mercy. People wound up with lower sentences. They would throw themselves on the mercy of the court. They would basically plead guilty at trial and turn the trial into a sentencing proceeding. So what are we gaining by having, if we go back to something like that, as opposed to just, okay, the person's admitting guilt and let's just, get on to a proper sentencing?
Yeah, I mean, I'm sounding like a broken record, but I think we gain a significant thing that we don't have right now, and which is that we don't have a check in the system right now. There's someone from the Fair Trials Organization called, her name's Rebecca Schaefer. She talks about the fact that right now in our system, we literally don't have anyone checking prosecution. We don't have anyone checking the police, right? So the police are a part of this as well. So I think we gain a lot if we rethink the system, and I think we do need to rethink the system. It's really great that there's a lot of criminal justice reform going on right now, but what we're not doing is looking at, and this is great, this forum is great to think about this, but we're not looking at the fundamental problem here, is we've set up a system that's not defensible under our Constitution, and there is a loss. We lose all of this check that was supposed to be, this jury was supposed to actually perform an important role in the system. And the results that Vanessa's talking about, that's what we see. We see those results. But I will even go so far as to say, outside of innocence, right, the jury was supposed to be an incredibly important check in the government.
Okay, Dan Satterberg, so it's a great 18th century theory, but it collides with 21st century reality. What's going to happen to the volumes of cases that we have? What's going to happen to incapacitation and deterrence and public safety? And what's going to happen to the trial as a meaningful safeguard if you take trials that go days or weeks and you essentially try to slim them down to, what did they take? 20 minutes a trial at the Old Bailey, 2 hours a trial in the colonies. Like, aren't there some important things we would lose if we kind of, blew past a bunch of the modern procedural protections in order to give everybody a trial?
You're right. Well, first I want to say that the New York discovery rules are bizarre and foreign to me.
They just got switched
They
too.
just got- okay, good.
We'll talk
I mean, we have open discovery, open file. Within a week of arraignment, you get everything we have. We'll continue to give it to you. I don't know how you, and to me, it looks like a game. If I'm not going to tell you what I got, it's like I'm playing poker and I don't have to show you, but you have to put your cards out there. So that, I think, exacerbates the unfairness, and I know that maybe over the objection of some of your state prosecutors, you're changing that, but I will assure any of them that you can operate in a fair, open discovery process and still win most of your cases. I think fundamentally one of our problems here is we don't want to admit that this exists. I remember when I was doing felony prosecutions, I had a caseload in the 80s, and we'd negotiate a serious case. We'd be up in front of the judge who, in the colloquy when you're pleading guilty, is the judge will ask the defendant, has anyone made any threats or any promises to you in order to get you to plead guilty? And I'm in my mind, quietly, I was thinking, of course we did. That's what we've been doing for the last month. But the right answer is no. No one did that. But it was all about threats and promises and prediction. And I think that there's some, as long as everyone's got the same information, the same ability to predict what's going to happen, that there ought to be some way to take advantage of an early admission of responsibility, that should get you some sort of benefit, that if you put the state to the expense and risk and the trauma for witnesses to go through trial, that it's going to be greater. But we should just call that a name. We should admit that it exists and say that there is a trial penalty, if you will. There's an analog I think, sort of in the civil rules of procedure, Rule 68, which is an offer of judgment. There, if defendant's being sued by the plaintiff, defendant can come in and make an offer and say, I think I'm willing to pay you $200,000. And if the plaintiff says, forget it, we're going to trial. If they don't do better than $200,000, then the plaintiff is responsible for their costs from that point where the offer is made. The analogous thing there being that at one point, one of the parties said, I think this is what this case is worth. And if you don't do better, then I don't have to pay more than that. I think the state, when they make their offer, when we make our first offer in an early plea negotiation, we've stated what we think this case is worth. Now, that doesn't mean that you can go to trial without any sort of risk, but since we stated that, why isn't that part of the record, and why isn't the court then have some sort of fixed ceiling that is a multiplier? You pick the number, 2, 3 times whatever that early plea was. But let's just say what the early plea was, and then let's say now that you didn't take that, you're gonna have to pay a little bit more. But it isn't sky's the limit. It doesn't go from 10 years to life. It doesn't become the death penalty when at one point we were willing to resolve it for something much less.
It's an interesting idea, kind of capping the size of the penalty or the discount. The trick is setting the baseline. But up until now, we've been talking about guilty pleas and plea bargains interchangeably. If we banned bargaining, how many of these defendants, Dan Sandberg, do you think would still be pleading guilty because there's a lay-down hand in poker terms, a dead-bang case? What fraction of these cases really are not disputable such that it would just seem nitpicky to even contest the guilt and defendants understand they're better off just fessing up?
Again, every system has a disincentive to go to trial, and you're talking about taking that away and saying that you won't be punished or penalized at all if you go to trial. I always wondered what would happen if, in solidarity, if all the defenders got together and said, never going to plead another client, we're taking all these cases to trial, and just jam the system. And I'm not giving you any idea you haven't already had, I'm sure. And it's only because of your individual, your responsibility to your individual client to do what's best for that client that makes people not want to jam the system. But again, we have settled on this equilibrium in major city court systems where about a 3% trial rate is considered a healthy trial rate. And it's really about all we can do because these aren't 20-minute trials. The cases, in fact, are way more complicated than when I was doing them. Now you've got all your technical, you've got your cell phone towers and your recorded phone calls, and you got to download the computers, and you got to do all this, there's so much more to it. These cases take forever. So you can't possibly do 100% of the trials, but you do, I think, still need to have an institutional incentive for people to accept early responsibility. And the flip side of that is some fixed penalty if you don't.
But I also think that the question assumes that the option is either go to trial and go to jail or don't go to trial and go to jail. And so much of plea bargaining, or like just negotiating or having a conversation, I like to call it, with prosecutors, is about working out an alternative to incarceration, something that will achieve the goals that the justice system is supposed to be set up to do, which is deterrence, which is incapacitation, which is rehabilitation, which is also punishment, without actually involving jail at all. And so many of my clients benefit from negotiations and plea bargains, not in that they just get less time, but they actually wind up early on ending up in treatment, whether it be mental health or substance abuse treatment or vocational training. And so I think the major fear I have is again, anything, I have a major fear in anything that creates a bar to leniency. But we're not just talking about jail. There's a lot, we are working very well, we have for a long time with the Brooklyn DA's office in kind of pushing them, and they've responded really well to think more critically about alternative to incarceration opportunities. And clients, it's not just for the non-non-nons, as it's been put, like the non-drug, or the non-violent, non-felony, there's another non out there. Non-sex, there you go. But in those cases too, to really think about what is going to be best for public safety, what is going to be best for the survivor of the crime as well.
Okay. One more question for Dan Satterberg. In terms of cooperation, the federal system has much more than the state. What fraction of your cases do you feel like, some kind of bargain is really essential to get inside the gang, break the code of silence, get, one person to turn on someone else for the murder or the like?
It's a very small part of the practice, I think, in most state courts. It's more of a federal thing that they like to do, to bring down Mr. Big by working up a chain. Occasionally, we'll do that. Occasionally, we'll have co-defendants, and one wants to plead early and be done, and the other one wants a trial, and so maybe we'll talk about that. But it's not a big part of our practice.
Okay. Suja Thomas, you're an abolitionist. Let's say we take abolition off the table. We're going to have some kind of pleas. What are the worst or most offensive features to your mind that you could mend without ending the practice entirely?
So Scott has talked about a lot of them. I'll just echo, and Vanessa's also mentioned some of them, and Dan's system has some of them. But I think we need to, everyone needs to have the discovery material. Before pleading guilty, it should be a rule that everyone has all discovery. I think that it should be the case, just like Scott mentioned, that you should be able to have any suppression hearings. Those are, and then actually, we also, where there are grand juries, this is another thing that has been stated, that if you are going to plead guilty, you have to waive your right to have the grand jury hear the case. So I think that all of those things should be off the table if in fact you're going to allow the system to continue.
Vanessa Potkin, so one of the things that troubles me in looking at the pool of people who pleaded guilty is that, as you said, sometimes evidence comes to light, it's troubling, it ought to lead both to this person's exoneration and some real soul searching, and instead the prosecutor says, okay, let's just enter an Alford or no contest plea, either not admitting guilt or affirmatively protesting innocence, but this way we'll insulate ourselves from liability. Is there a way to deal with that? Would simply banning Alford and no contest pleas help with the pool of innocent people, or would that just be hidden under a different rubric?
Yeah, it's complicated. I think that with the Alford plea, I mean, the fact that there is an Alford plea in itself, right? Where somebody walks into court and says, I am innocent, but I recognize if I go to trial, the government has enough evidence that I could be convicted, right? So I'm going to take this plea. Really is an acknowledgement in it itself of innocent people, pleading guilty. It is, it's a mixed bag, because if it's overused and it's used in circumstances where the state should just dismiss the charges, then again, it's something that you don't want to have on the table. On the other hand, for cases where maybe the proof of evidence or proof to support vacatur of a conviction is far less, for somebody to be able to maintain their innocence when the plea is really the best resolution, and the resolution, in that particular case, you would not want to take that off the table. It is, I think, makes a real difference to our clients who have had to resolve their cases in the end through a guilty plea and some type of resentencing, to be able to, still maintain their innocence publicly. So I wouldn't want to see the Alford plea be off the table, but it shouldn't be used in cases where the just result is for the state to dismiss the charges outright. And I think that, just adding to the discussion that we've been talking about, again, context, volume plays a big part of this, because, we have a system that just processes so many cases that, people on both sides don't have the time or ability or resources to put into a case before you got to the point where it's really a fair bargain. And so, whether that leads to us, rethinking and, decriminalizing categories of cases, I mean, we've just got a system that's so large that it's never going to be fair at this point.
One of the things that's been absent from our discussion until now is much mention of the judge. And I think it's very striking. I think that Scott's dream is to be able to persuade Dan or the other ADA about what seems reasonable. And notably, it's not about persuading the judge about what actually makes sense here. And some of this is because of mandatory sentences, right, which tie the judge's hands. And some of it is, if I wait long enough to get the judge, my client's going to be doing more time in pretrial detention. But some of it seems to be that judges are in this reactive posture at the very end of the process. And I wonder, does anyone see a role here, or any best practices in other jurisdictions where judges play more of a role? In the federal system, in a lot of states, judges are forbidden to take part in plea bargaining. And I wonder, look, I've never been a trial judge, I wonder whether that's right. If Suja is complaining that there's no balance of power or check here, are we worse off by banning judges from all the discussions and everything and just making them rubber stamps at the end than we would be if judges played some limited role that preserved a neutral fallback? I'm not going to penalize you if you decide to go to trial. Why aren't judges part of this conversation?
Let me address that. So Judge Rakoff here in the Southern District of New York has proposed that people in the federal system waive this idea that a judge can't be involved in the plea bargaining process, and he suggests that obviously not the judge who actually is the main judge on the case, that there be another judge that actually is the one who is suggesting the actual plea bargain. And so he thinks that in the system that we have now, that would be a really good way to try to lessen the effect of the prosecutor's influence on the case. And he has mentioned that Connecticut has, I don't know if anyone from Connecticut is here, but Connecticut has some type of system like that.
I'll just say that, in my experience, the only time when judges have actually gotten involved and said, no, I'm not going to accept this plea deal, is when it's been too lenient. Just going to say that. That is anecdotal for whatever it's worth. There was actually a colleague of mine who had worked out an alternative to incarceration in a gun case that carried with it a 3.5-year mandatory minimum, and the judge refused to take it, and you had the prosecutor and the defense attorney trying to see if we could somehow get the case in front of another judge that would be willing to take it. You know, when you say, you know, a lot of it's mandatory minimums, I think the majority of it, frankly, is mandatory minimums. It is taken nearly all of the discretion away from the judge, except within the minimum, you know, to the max after trial, to do, frankly, anything. And under New York law, there's another part of the law that the judge can order what's called judicial diversion, so an alternative to incarceration over the prosecution's objection, but only when the charge is nonviolent and when they don't have a violent charge in their past, and so that's also limited. The one time when I've been able to get a judge, there's kind of ad hoc ways you can get the judge involved. You approach the bench and you provide the judge with some more information about your client. You provide them with what's called a pre-pleading information in addition to the prosecutor. And they might say, come on, just like the Brooklyn plea, like, come on, prosecutor, I want to see your supervisor. Sometimes we'll have the supervisor come down and have that conversation. But if the prosecution says no, that's it. The one time I've been able to actually successfully get the judge involved to get the right outcome, I actually had to file a motion to dismiss in the interest of justice. And the judge agreed to hold the decision in abeyance pending my client doing a drug treatment program while the case was still open, and upon successful completion agreed that the interest of justice would allow for dismissal, and so that's what wound up happening. But mandatory minimums take the judges completely out of the equation, except for the old, come on, let me get your supervisor, do a little hand-wringing, but they really can't do much. And the only time when they actually can do something, which is to say no, it's never in favor of more lenient. It's never saying, I'm not taking this because 2 years just won't do anything for the public good, it's too harsh. Come back to me with an alternative to incarceration. That doesn't happen. It happens the other way.
So we've been talking about the judge's role in sentencing, and you're saying they don't go too lenient. It's interesting because at common law, actually, the judge had a role in recommending clemency. You going to?
I just wanted to say that in our system, at the time of the plea, the person who knows the least about the case in the room is the judge.
Right.
And often the judge that takes the plea isn't the judge that does the sentencing. So the sentencing might be put off for a couple weeks, and then the sentencing judge, we have a determinate sentencing scheme. So you have a little box, and you're going to be between 15 and 23 months, and that's what the judge can sentence you in. I think there's tremendous pressure for the court to honor the plea negotiation process, because the court knows it's a matter of survival for the court as well. Right. If you start throwing those out and doing something that disrupts the smooth operation of the machine, which some people are advocating for, that's going to just make things more difficult for the court as well. So I think there's deference from the court to the attorneys. You've settled on this, and 98% of the time, our judges will follow the recommendation of the parties.
So there's this reactive posture, lack of information, and this interesting that the disconnect in federal court too between sometimes the judge who takes the plea and the guilt, and then sentencing, which you might think those things ought to be connected. But I want to ask Vanessa about this, that we've been focusing on the judge's role at the sentence, but what about the judge's role in ensuring factual guilt? That there's supposed to be a factual basis for a plea, and judges are, are they rubber stamping this? Could they do more? I mean, in the military justice system, there's a real probing into the facts. Would that have helped some of the people you're exonerating? Or conversely, I've gotten into debates with people who say it's good for innocent people to have the option of pleading guilty. I was surprised to hear it. But because the alternative that they face at trial is even worse, or rather, should we be encouraging them not taking the pleas and then making the cases fall apart at trial, we hope?
Well, the problem is because of, many of the deficiencies in the system, and, just as we talked about before, many clients are relying on public defenders. Many public defender systems are totally overwhelmed. You have places where a public defender is spending 7 minutes with a client before the case is resolved, or, they're in New Orleans, there were, like 10 investigators for 20,000 cases per year. And so, insisting that that person go to trial is not, going to necessitate a just outcome for them. So, I think that until we fix some of these other problems with the system, it's, right now it is so baked into our system that there's no way to just eradicate it without addressing really the causes. The problem with the guilty plea system, again, it's a symptom of all these other problems with the system.
Good. So I want to go back to Dan Satterberg and talk a little. Some of the things, you contrasted early on King County with Tacoma County. And it seems like regulating plea bargaining depends in part on your choice between this, let's figure out the right place and stick with it, and versus let's throw in the kitchen sink, wide variations in charges, sentences, et cetera. How do you operationalize that? And in particular, what do you think about the role of the prosecutor early in the process, as you became famous as the screening bargaining trade-off? New Orleans had this for a time where they really tried to figure out up front what were the facts, do a little bit of investigating, and try to then hold the line on the charges that were filed rather than just using all of it as leverage.
I think there's more integrity in a conservative filing approach. It's less of a creative writing thing where you're trying to spot the issues and add charges that may not have any evidence behind them. I do think there's I'll just tell you how it happens in our office. We'll file a case, it'll go to an early plea unit. There's probably 8 deputy prosecutors who handle the negotiations for 7,000 cases a year. So they have to know enough about them to have informed discussions with defense counsel. But if the defense counsel says, we're going to note a motion, we're going to suppress, I want to interview your witnesses, we're going to set this for trial, then we have to take that case out from the early plea unit and send it to a trial attorney. And then the trial deputy prosecutor has to get that ready for trial. And so that's when theoretically, your best deal was at the early plea unit. Now that I've had to send it down the line to the next person to spend a lot more time on it, actually that case might fall apart. You might get a good deal toward the end, but it also might be that as we investigate, we talk to more witnesses, we find out that in fact there are additional charges that we can prove. And so I think the necessary evil just in dealing with the sheer numbers that we have is that we have to make that best offer right up front early on.
So what digging do the charging attorneys do? What do they know about the case when they're starting off? Because that seems to be a key problem here. Right. Are we doing this in the dark, or have they probed the witnesses and the possible defenses early on enough before the dickering really gets going?
So Washington State is an information state. We don't have grand juries. We don't have preliminary hearings. We just file based on the police report. So at the time we're initially negotiating that case, we haven't met with any of the witnesses. We haven't talked to anybody. After that gets assigned out to a trial attorney, now they have that obligation to start to meet with people. We also do interviews. If the defense wants to meet the witness, we'll sit with them and while they ask questions, and we learn things that weren't in the police report from those. So we do dig by talking to the people who were there when it happened. Sometimes that gives us more information to look at additional charges. Sometimes it makes the case kind of collapse. It looked better on paper than when the people came in.
All right, so last question for you and for Scott Heckinger, and then please, your questions. What could we do to learn more about cases earlier? Can the defense lawyer, provide information in time before the prosecution gets committed going down the road? Could prosecutors call up the officer or the key witnesses or things so that we don't go down this road of, okay, it could be any number of things, and then it's just all a matter of bargaining? Is it possible to figure this out early?
So I'll just say that we just passed transformative discovery overhaul in New York. For years or for decades, we had one of the 4 worst discovery laws in the entire country. Prosecutors were entitled to withhold, and they did all too often. Although Brooklyn was a model for open file, they did more than they were required to until the day of trial. Just last week, overhaul was passed, in large part because prosecutors from Texas came and told New York prosecutors to basically stop fear-mongering. Early discovery, automatic discovery is not leading to blood in the streets. It's actually leading to fairer outcomes and fairer pleas in some cases. And so the law requires, first of all, prosecutors to turn everything over early, within 15 days of arraignments. They must turn over discovery before any plea deal. And importantly, there's a provision in the statute that does not allow prosecutors to condition that plea deal on waiver of that discovery. And so that is one thing. It's a major legislative change that has happened, that is going to transform, I believe, New York justice and ensure that everyone is at the very least on the same playing field in terms of information when those decisions are being made. But legislative overhaul takes time. It's very difficult. It took decades in New York, and it's certainly, while we were one of the worst in the country, it's not perfect elsewhere. Prosecutors can step up. For just requesting that information early on, I think, I don't think that should be the best offer you ever get. I don't think there should be a penalty, even at that early stage, not just for going to trial, for just requesting additional information.
Dan Sanderberg, before we go to questions, so even if we have open file as it do in Washington, that's only what's in the file. It doesn't mean you followed up with the witnesses or the alibis or the other things like that. How much can you figure out about a case very early on so that it really will shape the charging and the bargaining?
So the pressure is, in a serious violent crime, I have 72 hours from the time of arrest to file that case. And sometimes the police don't get it to us until 48 hours have gone by or more. And so we're really relying on what the detectives have seen in the field or summaries of witness statements that were long taped recording statements that no one's had a chance to listen to yet. So, if you don't file within 72 hours, that person's released back onto the streets, and often the crime is such that that's not an acceptable alternative. So cases do change. They do change with age. Once in a while, we'll have the luxury of being able to contact a target through their attorney and say, we're thinking about filing a charge in this case. Well, come tell us why we shouldn't, bring us more information. But most of the time, most major district attorney's offices are responding to the violent crime from yesterday or the day before, and we have to act quickly. So that's where then the early plea process can go on for some time, but we're not going to know anything about that defendant for many weeks.
We've got some time for some questions. Courtney will bring the mic over. Please identify yourself and keep it to 2 or 3 sentences.
Keep the question to 2 or 3 sentences. Good morning. My name is Leah Brown. I'm at the Southern Poverty Law Center now, but I was a public defender in D.C. For a decade. So the first comment is that there still is this coerciveness in the plea bargaining, even when there is a stellar public defender that's well-trained and well-resourced to try cases. My question is about the police. And to you, Mr. DA, you have more than 100-fold cases coming in that your office is able to try. And it seems like the emphasis is on individuals, not defendants, but people who have to make decisions about efficiency. And I'm wondering if there's a disconnect, if perhaps a solution might be to have police arrest less people. I challenge the notion that most of the plea bargaining is in serious violent offender cases. I don't think that that's really what we're talking about. We're talking about drug cases, we're talking about thefts, we're talking about robberies where there was no gun and no wound. So I guess the first part of it, I know it's more 3 sentences,
All
but
right, so
the
the
first
question
part of it
is,
is the...
could we arrest and charge fewer people? Would that be a sufficient solution to the problem?
It would help a lot. In fact, we have in Washington, we've legalized marijuana. We're making $300 million in taxes on it this year. I don't file driving while license suspended in the third-degree cases because that criminalized poverty. I don't prosecute people for possessing under a gram of any drug at all. Those weren't things that the police were happy about, but I'm the gatekeeper and I can turn the spigot down as I need to. But at the end of the day, we have fewer cases than we used to, but they take longer because they're more complicated. So there's still that weight on the system to go through 100% of the cases that are filed, but only try 3 or 4 or maybe 5% of them. And that's what we're talking about. How do we do that in a way that doesn't deprive people of their constitutional rights, that doesn't penalize them, at least if it does penalize them for exercising their constitutional rights, let's just say that it does and fix a cap on that.
Scott, do you want to respond briefly?
No, I mean, I'd just say, thank you for the comment about the public defender offices. I think Brooklyn Defender Services and PDS in DC is a good control. We have extraordinary resources, investigators, immigration attorneys, collateral consequences attorneys. We have relatively low caseloads. I mean, 100 is way too much still, but it's not 400, 1,000 in other places. And the guilty plea percentage is still 95% of convictions come from guilty pleas. 99% of cases do not go to trial. And so, yes, of course, there is a crisis in public defense funding and lack of resources, which is a significant issue around the country. But the problem with pleas and guilty pleas and the people who it affects goes far beyond just resources in public defender offices.
Other questions? In the back.
Hi, I'm Chet Kerr. I have a question. You've talked about some of the problems and some possible solutions. There's obviously an accepted percentage of people who have pled guilty who are innocent, factually innocent, and then obviously many other people who may have committed the crime, factually have committed the crime. Do you see different solutions to try and address those problems, or should the solutions you're coming up with apply across the board, whether or not someone's factually innocent or not?
That's a great question, and I stumbled on your the first part of the question when you said there's an accepted number of innocent people, and I think I agree. I think it's sort of built into the system that we have so many cases that yes, we're going to need an innocence project, and we're going to need prosecutors who are sensitive to that. I don't know how you treat them differently as they come in the door. Although I will say that it is unusual for a defense attorney to come in a negotiating session and say, my client absolutely wasn't there, here's the alibi, here's this, that. But most of the time, the evidence is there for us to go. And so when someone says they didn't do it, then maybe there should be a different line where that case goes and is handled by a different group of, that pleas should be for the guilty, and that maybe there should be a different line for people who insist on their innocence. That's a tough question because you're right. Right now, we just lump them all together and churn them through the machine, and a person just has to make tough choices, and risk much greater punishment if they don't plead guilty to something they didn't do.
But I also think we cannot lose sight of the guilty, people who actually did something, but just because they did it, first of all, they might have a defense. It might be constructive possession. They're in a car with 4 other individuals. There's a gun inside, or they're charged based upon accomplice liability, didn't share specific intent. Or they just did it, but they did it because of really complicated reasons that that prosecutors need to be thinking about more critically. It was driven by poverty. It was driven by crime. Even violent crimes were driven by violence and trauma. And so I always hesitate to talk when we're getting these conversations to really just only focus on, those who are innocent or might have just been stopped and frisked unconstitutionally and are so therefore legally innocent. But this conversation is really critical about for those who committed the crimes too, and it's really critical that in negotiations, we be thinking about the fact that even guilty people, maybe even especially guilty people, deserve leniency and deserve more nuanced negotiation.
I would just add to that and say that it would seem to be untenable to have, two different tracks, and who is determining at that point who is innocent or guilty. And, coming from the Innocence Project, the reforms that we seek to implement that throughout the system are not just designed for people who could potentially be innocent, but really to make the system, fairer and more just for everybody coming through the system. And so, if you have a constitutional right to a trial, it doesn't, and the government is supposed to prove their case, it's still untenable, even if you did the crime, to have a system where the prosecutor has extraordinary discretion to overcharge, and the government doesn't have to prove their case, and maybe they wouldn't be able to if you went to trial, or, your constitutional rights were violated in some other way. So, by no means is it the Innocence Project's platform to say there should be two separate tracks.
We've got time for maybe 2 more questions over here.
I'll keep it to pretty short. How much impact do you think it would have if prosecutors were required to prove their cases beyond a reasonable doubt to a grand jury and also present exculpatory evidence to grand juries before making plea offers?
Well, interesting, because in New York, as I understand it, they already do have to present exculpatory evidence. That's not your experience?
No, it's not my experience. It's not. In fact, even when I request it, they often will refuse.
And we don't have a grand jury system, so I can't answer your question.
But the answer would be enormous difference. Enormous. Let's talk later about how to institute that policy.
Can I just add that it's kind of an interesting fact that the grand jury right is one of the few rights that hasn't been incorporated against the states, and so a number of states do not require grand juries, and that's another injustice that we need to be thinking about.
All right. Other questions?
Good morning. It appears that this conversation tends to focus on basically crimes in the streets rather than the crimes in the suites. I guess particularly for Professor Thomas, what about the agreements such as NDAs that go to those who are very rich, who would basically benefit from what we would call the Holder Doctrine, where we try to basically get some money out of a deal and everybody goes free? What about those type of deals?
Yeah, I mean, I think across the board, plea bargaining is unconstitutional. It's problematic, regardless of who the defendant is. I certainly think, and I had a conversation this weekend with someone who's representing people in that suite that you're talking about, and they certainly oftentimes, want that benefit. They want that benefit associated with the plea. But problematic, all of this is problematic because there shouldn't be a penalty associated with the jury trial. That benefit is a penalty to some people, and we need to treat people the same. And so I think it's problematic regardless.
So I think we've got a minute or two. Is there a last one? Over here, in the middle.
I guess I just want to hear your reaction. In England, they have statutory penalties, statutory discounts, simply depending on when you agree to plea. Early as possible is the third off, later is the fourth off, later is the eighth off. I know, Scott, you wouldn't mind it. It's a bar on leniency. But, we're looking for places beyond the prosecutor. We're looking for the legislator. We're looking for judges. You can't, cherry pick a piece of another system, but what about that?
I like that system because it's more transparent and it's more predictable, and it might change, the way that the defense attorney counsels her client to say, that this is going to happen. You got another, 2 weeks, and then this is going to go up. And we make people make tough choices. I mean, that's what's part of being charged with a serious crime, is you have to make some tough choices. But I think that my thinking about this, preparing for this conference, was just that what's missing is any sort of transparency, any sort of accountability, and the unlimited amount of penalty that one might face if they end up going to trial. And I think that's an area where criminal justice reform can be focused. Not getting rid of plea bargaining entirely, because I can't, that's my water. I don't know how we would swim without that. But make it obvious and transparent and cap it so that we don't get these grotesque outcomes.
I'll just say I'm not like at all sympathetic to the idea of like prosecutors having to work harder overtime and putting in time balanced against a person's right to trial or just right to due process and information. And so, okay, you have to put in some more time, you need to prepare for your hearing. The worst that happens is you lose and you might have lost a weekend. The worst that happens for my clients is they wind up pleading guilty either to something they didn't do or pleading guilty to a worse crime and more time, or face mandatory minimum sentences. So, you know, I just do not like the idea of early pleas and there being one-time offers because, you know, we're going to put all this time. Put in the time. I'm sorry. Make the system way smaller on the front end, decriminalize, decline to prosecute the majority of crimes that shouldn't be in the system to begin with. Focus attention on maybe the crimes that should be on the books. Think more critically about alternatives to incarceration. But don't penalize my clients for exercising their constitutional rights.
And just to pick up on that, I've always thought it's a great idea in theory, but in practice, the problem is with prosecutorial charging discretion, so much can be done in terms of setting what the baseline is the discount comes off. Now, maybe this constrains the size of the discount after charge, and maybe that's not such a big deal if you're really charging within 72 hours, but if we want to talk about the white-collar cases where there's lots of pre-charge negotiation, that still remains malleable, and you can't really address it by a post-charge reduction discount. Please join me in thanking my panelists for a wonderful panel.
Good job, guys.